Hello, my name is Rose Riley, and I'm a member of the League of Women Voters of Washtenaw County. Welcome to our online candidate forum for the November 5th general election. The League is a nonpartisan, nonprofit organization that promotes voter education and participation, and we host candidate forums to help voters make informed choices. Now, let's hear from the candidates.
My name is Carolyn Madden, and I'm a member of the League of Women Voters of Washtenaw County and the Restorative Justice Committee of the First Unitarian Universalist Church of Ann Arbor. Welcome to our online forum featuring the nonpartisan candidates for the 22nd Circuit Court. This forum is co-sponsored by the League, the Dispute Resolution Center, the Restorative Justice and UU Civs of the First Unitarian Universalist Congregation of Ann Arbor, and the Washtenaw County Bar Association. The sponsors are nonpartisan organizations that promote voter education and participation. Our moderator this evening is Belinda Doolin, Executive Director of the Dispute Resolution Center. Ms. Doolin will now explain the format and get us started.
Thank you, Carolyn. Good evening. My name is Belinda Doolin, and I will moderate the forum tonight. It is my honor to introduce the two nonpartisan candidates running for judge of the 22nd Circuit Court, Janan Hamoud and Jeffrey Worrells. Thank you, candidates, for participating in the forum tonight. We are now ready for your opening statement, and we'll begin with Ms. Hamoud.
Thank you, Ms. Doolin, and thanks to everyone who put this together. I know it's a lot of work, having been on one of these before from the other side of it. So my name is Janan Hamoud, and I'm an attorney in Washtenaw County. I've run my own practice for over 11 years here in Washtenaw. I practice primarily criminal defense, family law, and civil litigation. I am actively involved in our community both as a resident and as an attorney. I have served on the Washtenaw County Bar Association and the Women Lawyers of Michigan Washtenaw region since the early years of my practice in various capacities with the Washtenaw County Bar as a new lawyer section co-chair, director at large, a member of the Judiciary Committee as a co-chair, and a secretary for the executive board. I currently serve as treasurer for the executive board, as well as co-chair for the Public Service Pro Bono Committee and the criminal law section. With the Washtenaw County Region of Women Lawyers Association, I just finished off my last term as the immediate past president and have been on that executive board for over 7 years. I live in Lodi Township with my husband, Oscar Rodriguez, who's also an attorney, our two daughters, ages 5 and 3, and our boxer pup, Fitzgerald. Thanks for having me here, and I'm excited to get started.
Thank you. Mr. Worrells, your opening statement.
Thank you. I'd like to thank all the organizations for inviting me to this forum and giving me the opportunity to participate. My name is Jeffrey Worrells. I am born and raised in Michigan. I'm a proud graduate of Eastern Michigan University. I attended law school at Tulane University down in New Orleans. I was called to return home where I was born and raised and wanted to reside. I've been an attorney for over 12 years now. I primarily practice as a litigation attorney. I work in a small firm handling litigated and contested matters. I primarily practice handling family law cases, real property disputes, probate litigation, and civil and business disputes. All of what I handle is the type of issues that would come before the circuit court. I've been motivated to run for judge because I've always wanted to be a judge. I've always believed that the law should be applied fairly to everyone. As I studied the law, I always thought, it was important to get the right answer, not necessarily what your side or you're advocating for. So that's what motivated me to run for judge, is to ensure that it gets applied fairly to everyone. I currently live in Pittsfield Township with my wife, Lisa, and my 1-year-old daughter, Nora. Thank you.
Thank you. Thank you both for your opening statements. Now we'll transition to the questions. And for the first question, we will start with Mr. Worrells. The question is, a critical job of a circuit court judge is to manage complicated civil cases. What is the most complex piece of litigation in which you have been involved?
The most complicated litigation I've been involved in is a recent trial. It was actually a probate trial involving a will contest. There were 5 interested parties with different viewpoints on what the will should, whether or not the will should be admitted or not. And among those 5 different viewpoints, I represented one of the interested parties. And it was a 10-day trial with over 20 witnesses, including the interested parties. It handled a lot of different issues, such as will validity, undue influence, and similar issues. And it was pretty complex. So thank you.
Thank you. Ms. Hammoud, same question.
Thank you. A number of cases jump to mind, and I'm going to hopefully have time to talk about 2 of them. This was earlier on in my career. I had a client who had a car that was parked at a parking garage downtown Ann Arbor near her apartment complex. The garage was affixed to her apartment complex and was managed by the apartment complex by way of interest in parking. But it was also, managed through public parking, but it was also managed by the Downtown Development Authority, and a pipe burst and flooded the basement of the parking garage. The car was destroyed. It was a total loss. It had been custom built for her. At the same time, her family was getting we were separated. Dad had not kept up the car insurance on the vehicle, so the car wasn't insured. So finding out which party was liable, there was quasi-immunity to the Downtown Development Authority that maybe precluded them from being in the case. Republic Parking was responsible for the pipe, but who was responsible, or Republic Parking was responsible for the infrastructure, but were they responsible for the pipe? What culpability did the apartment complex have? And I ended up, through discovery and learning this out, having to join multiple parties to the lawsuit until everybody was in that might have had some sort of liability before we could reach a resolution. More complicated than that, I think, perhaps in a family court case I have, it was an adoption proceeding that occurred while there was a pending custody dispute in Ohio. Mom and her spouse had gotten married, and the 2 of them wanted to adopt her child. But mom and mom's partner from Ohio had a separate custody proceeding pending where adopted mom had legal rights, but mom, who was just in a relationship, was asserting rights as a third party, and whether or not that court even had jurisdiction over the kids was an issue. So we had to wait for that to resolve before we could move forward.
Thank you. We will go to the next question and begin with Ms. Hammoud. Other jurisdictions, such as Cook County, Illinois, have created specialized restorative justice courts. What is your position on expanding restorative justice options in the Washtenaw County courts?
As a criminal defense, thank you. As a criminal defense attorney, I'm very aware of the restorative justice program that we have available to us in our county. I think we need to make use of it more. Currently, it's used primarily in juvenile court proceedings, but I recently attended a roundtable discussion where an individual from Iowa, who is sort of a pioneer in this field, explained how it could be used in adult criminal court and a wide variety of cases, ones that we might not even consider using in our county. From my understanding at that roundtable, I learned that if you don't use the resource, then you either lose funding, and if you don't have funding, then you can't use the resource. And if you're not using the resource, then you can't train members to be a part of the program. And if you don't have members to be a part of the program, then you don't have the resource to use. So it's got to be a group effort of everyone coming together to present more value to using the restorative justice program that we have, to expanding it, and to making it a more common resolution in adult court. I think that restorative justice provides a substantial benefit both to a victim in a case and to a defendant that just our typical adjudication process may not, in terms of closure, in terms of moving forward with some sort of dignity, respect, confronting the person that harmed you, and also learning more about who they are might put a victim at ease under certain circumstances. And it also still maintains accountability for a defendant in a criminal case, but also gives them a sense of how what they did impacted someone else. And as we've seen, these types of models lead to a higher rate of recidivism. So as judge, I would encourage the use of restorative justice models. Thank you.
Thank you. Same question, Mr. Worrells.
Thank you. I think restorative justice policies and programs are great. I think the more tools in a toolbox for a judge, the better. I think it's based on, you look at what the purpose of sentencing and criminal law is, and is it just to punish or to try and reduce crime in general and help society overall? My view is that criminal sentencing shouldn't be based on just punishment, but we should also look at ways where we can keep people from coming back and keep the same people from, using the courts and jail as a revolving door. I think the restorative justice programs, from what I've read and seen, can do just that. It's a different alternative rather than just the old hammer and nail, send somebody to jail for breaking the law. Restorative justice programs involve the victim and not just on a precursory level that sometimes the criminal law does right now, but they become a stakeholder in the result. And then it involves the defendant taking accountability and becoming involved in owning up to what the defendant, crime committed, and understanding, how it impacted the victim, and the victim can understand, where it comes from and what led to this. And, with conversations and these programs, a healthy result can be achieved from all the parties involved. So I do think it can be a helpful tool to avoid, the long-term same thing, so we can avoid further over-incarceration in this country. Thank you.
Thank you. We'll move to the next question, and we'll begin with Mr. Worrells. It is often said that justice delayed is justice denied. What management experience do you have that would prepare you to manage a docket effectively?
Well, I do think it's important that the courts move swiftly and don't delay justice, because oftentimes people get frustrated and burned out. So in my experience, I've managed my own case files throughout my career, upwards of 50 files at a time, contested matters and the like. And so with managing your own files as an attorney, there's a lot of irons and a lot of fires. You have to be aware of deadlines. You have to be aware of what's important. You have to be accessible to your clients. It's a lot of multitasking, and any litigation attorney knows that, it's not easy task juggling all these things. I think you can apply those same concepts to the bench and managing a docket, and understanding what's important and keep things moving along. One thing I do think is important too is that judges use the most of the courtroom time. As an attorney, there's nothing more aggravating than when the call time is 8:30, but the judge doesn't take the bench till 9. That's 30 wasted minutes, 30 minutes that we can't use. And so it's little things like that where if you're properly prepared and you show up on time and you take and you understand the issues in front of you, you can manage the cases more effectively and avoid lawyers and parties and all that from rambling on, and you can get right to the issues at the heart of the case to keep them from moving on. Lawyers and judges also love adjourning things. I don't think adjournments should just be granted willy-nilly. I think there should be some reason for adjournments. We have deadlines and scheduling orders to keep people on task, and I don't think the courts should kick the can down the road, because that ends up with justice delayed and aggravated parties. Thank you.
Thank you. Ms. Hammoud, same question.
So I've managed my own practice for the last 11 years, and I don't have any support staff. I set my own appointments. I manage my calendar. Being in the 3 different areas of practice, sometimes I'm in our courts, in separate courts, both in multiple district courts and circuit court on the same day. I do mediations. Yesterday, I was in court on 2 separate Zooms when I was in court in person. The mental load on that alone is sometimes tasking, but I have done that for the last 11 years, and that includes billing and just the general day-to-day taxes, accounting, and running a business. I'm also, as I explained in my intro, in leadership positions on multiple organizations. I plan events. I'm responsible for reporting to the members of the other board and the members of the organizations with updated tasks and event information. I'm on the homeowners association for my subdivision and have been for, I think, the last 5 years. And we run a budget in that sense. I'm responsible for the upkeep, landscaping, snow removal contracts. And I am our home manager at home as mom. And I am responsible for managing my kids' schedules, their appointments, all of that, the real life experience and in my professional experience. I believe that I have, very good organizational skills. Anyone who meets me will tell you that. I am always on task, and I'm a list maker. So that's kind of what you have to be like when you're running a docket. You have to be organized. You have to be able to structure the day. You have to make the best use of the time and the best use of all of the time that you have when you're running anything, and especially a congested docket.
Thank you. We'll move to the next question and begin with Ms. Hammoud. How would Michigan's truth in sentencing laws affect your approach to sentencing?
So, truth in sentencing laws basically make it so that if a defendant is sentenced to time, they are going to serve the time they're sentenced to, as opposed to a much lesser sentence because of something like good time, which was removed some time ago. And knowing that a defendant is likely to serve the amount of time that you are sentencing them to, you have to take very seriously any prison sentence you hand out. Now, there are sentencing guidelines in our state that judges have to that are supposed to use and follow. And with the sentencing guidelines, it kind of eliminates some of the discretion judges used to have. But of course, sentencing is always at the discretion of the judge. I know that there is a new act that's floating around, that the Second Look Act, which will allow a defendant having served a certain number of time for a certain type of crime to ask the judge for reconsideration of their sentencing. And I think that's a very good approach to what we currently have in place. It's a good balance between, a victim being assured that somebody's going to be sentenced to the time that they're served, but also somebody who's done the work that they need to do in prison in terms of the programming that's available, the reform that they can manage, getting somebody to take a second look at that. At the end of the day, when sentencing someone, you have to consider a totality of the circumstances. And if the circumstances permit and consideration for deviation from sentencing guidelines would be appropriate, I would certainly consider that. And in the opposite direction, if an upward deviation, I don't know if I said downward first time, but if an upward deviation would be more appropriate under the circumstances, I would also consider that.
Thank you. Mr. Warrose, same question.
Thank you. Obviously, sentencing people to jail is serious matters and something you can't do flippantly. It's something that requires a great deal of thought and looking at the factors of the case. there are sentencing guidelines, and the truth in sentencing laws do require that the minimum time be served. So that's something definitely that needs to be taken into consideration when fashioning a sentence. Understanding that if this is the floor, that person is going to be locked away and incarcerated for at least that long, it's certainly going to play an impact on the decisions. Obviously, with the guidelines, there is wiggle room to deviate, but you have to look at what's appropriate and why to deviate from the guidelines, and deviation shouldn't necessarily be the norm. Obviously, every case is different, and you need to look at the specific factors, though. But knowing that there's that floor and that minimum, I think does play a role in terms of, whether or not this penalty is appropriate. As I stated earlier, I don't believe the goal of criminal sentencing is just to send people away to jail for as long as possible. I think it's to protect society and make sure that there's accountability for the defendant's actions. So you take that into consideration when you're evaluating the sentence and the truth in sentencing laws. Thank you.
Thank you. We'll move to the next question and begin with Mr. Warros. How would you handle a case in which your let me start again. How would you handle a case in which your personal beliefs conflict with established law or legal precedent?
My opinion is that my personal beliefs don't belong in the courtroom. I don't think I should be imposing my personal beliefs over established precedent or the laws in place. I think nowadays there's a loss of trust in the judiciary because there's a lot of judges who are doing just that, and on a more national level than the Washtenaw County Circuit Court. I think matters at the Circuit Court level in Washtenaw County aren't as politicized, but either way, when they do arise by occasion, I don't believe I should be imposing my personal beliefs. I believe I should be listening to the parties, listening to what their dispute is about, and making a decision based on the facts and the law. And that's what's going to guide me as a judge, and not my personal beliefs. Thank you.
Thank you. Ms. Hammoud, same question.
Thank you. At the end of the day, the judge's job is to apply the law, irrespective of whether or not the judge may or may not agree with the law. I disagree with the statement that personal beliefs won't have a place in the courtroom. And I'll just give a very basic example of where that could happen. If you're a parent and you're presiding over a family court case, and one parent is accusing the other of being negligent and seeking supervised visits, and the allegation is based off of, an injury that occurred during parenting time that seemed to be an accident. As a parent, I would know and understand that sometimes accidents do happen, and that children do get injured even under the most watchful of eyes. So the circumstances that brought this family into the court were simply just that, I would be able to use my experience and my belief towards parenting to make the most informed decision based on the facts presented to me. So experiences and beliefs do matter. And that's just one simple example. If you have experiences as a criminal defense attorney, for example, I've seen what happens in criminal court. And I've seen sometimes the representation that a defendant may or may not have and how that's impacted the outcome of their case. Those are, and what rights a defendant is permitted to have under the Constitution. Those are beliefs that would influence the way a judge would act. And so beliefs do influence the way a judge acts, and the law is the law. Your beliefs can conflict with the law, and you should always apply the law because that's what you're required to do. But how you practice or how you preside in your courtroom really sets a tone. Are people welcome? Is everyone given a fair opportunity? That comes from your experience and beliefs. Thank you.
Thank you. Ms. Hammoud, the next question will start with you. What, if any, considerations would you give to mitigating circumstances, such as history of domestic violence, PTSD or other forms of trauma when making sentencing decisions?
Thank you. So mitigation is always important in when you're advocating. And I think when you provide mitigation information to a judge, it really gives a judge a better understanding of the root cause of somebody's justice involvement. And without that information, you can't really identify what type of resources the person in front of you can benefit from the best. So understanding if somebody came from a home where domestic violence was present, whether it's from their childhood or into their later teens, might give you insight as to a trauma response that they've developed, or some sort of counseling or therapy that's required. If they come from a home that there was substance abuse or drug abuse, understanding that might lead you to direct that individual to different types of programming or providing additional support resources. Mitigation is my specialty. I think every time I'm in court and I'm asking for something on behalf of a client, I have gone to the very early days of that person's childhood to see and understand what made them the way they are and what type of experiences they might have had that led them to make choices others in different situations did not have. What kind of people around them were there to provide support or not provide support. And I try to set that up as a picture of who this person is and why I think they should or should not be sentenced to prison, what I think they actually need to better themselves and be safe in our community. And the more information that you can provide to a judge to that effect, the more you can help the person that's in the courtroom. Thank you.
Thank you. Mr. Warros, same question.
Thank you. I think the worst thing a judge could do is have tunnel vision. So I think it's important to consider all mitigating factors that are presented, especially things like exposure or victimization of domestic violence or exposure to trauma. They can help explain the action. That's something to be considered when fashioning a sentence. As I've previously stated, my goal isn't just to punish for the sake of punishment. The mitigating factors can kind of explain some of the behavior sometimes, and that can lead to fashioning a sentence that's more appropriate for that particular person. Again, more tools in the toolbox, the better. More knowledge about the situation, the better. So with the proper knowledge and the proper tools, you can effectively use that information to sentence the defendant in an appropriate manner to ensure that the public is protected and also that the defendant is on a path to avoid recidivism. So I think it's definitely important to consider any and all evidence presented so that you have a full picture. And it's important for a judge to be open-minded to everything and not just focus on what the crime was, whether it was done, and what's the sentencing guidelines. I think it's important to consider everything. Everything needs to be on the table when making these important decisions. Thank you.
Thank you. The next question will be our last question for the forum, and we will begin with Mr. Warros. What steps would you take to maintain order and a fair trial when presiding over a case that attracts public scrutiny or media attention?
Well, I think as a judge, if you're doing the job the right way, your courtroom should have order to begin with. And I think it's important that the attorneys that are appearing in the courtroom understand that when they step foot in the courtroom. And so if you have that from the get-go, if you have a high publicity trial, it's easier for the attorneys to understand how you run your courtroom and how you can maintain a docket and a case to avoid a circus. And I think some of the ways you can do that is just, ensure that everybody in the courtroom is treating everybody else with respect and dignity. I think sometimes lawyers can get away with too many underhanded or backstabbing comments that are helpful. I think it's important to maintain a basic level of respect for everybody, litigants, attorneys, staff, just people from the general public watching. And I think in policing that and making sure everybody's abiding by that, that can set the tone to ensure that people understand that you mean business and this isn't a courtroom to mess around in. I've noticed, with the advent of Zoom court, with people appearing on screen and thinking it's video, a lot of people don't take it as seriously as they do in person. And so, with it in person, you can enforce the rules and keep people honest and fair and hold them accountable, and ensure that they're doing what they need to present the case rather than put on a show. Because at the end of the day, what is important is the underlying case, not impressing the media or other people. Thank you.
Thank you. Ms. Hammoud, same question.
So usually when a case is getting a lot of attention in the media, it's a criminal matter. And it's very emotional to the community. There's two sides of the story that are hurting, and there's the defendant's family that is expecting to suffer the loss of their loved one if they're convicted, and then there's the victim's family that has suffered the loss of or harm that's caused by the conduct that's been alleged to have occurred. And sentencing is when there's a potential for the courtroom to run out of order, so to speak, as it's been put. But I think when you recognize that and you put safeguards in place in advance, maybe do the sentencing at a different time than is usually permitted, not run it on a regular docket, so that there's enough time for everybody who wants to be there to make a statement, to speak. It's important for people to be able to have the opportunity to say what they want to say. Have additional security available in case something happens, to kind of prevent anyone from getting hurt on the day of sentencing. And really just, it's not, you don't have to put people in their place, but it's recognizing that the situation or the case is going to have a very high emotional response from the people who are involved. That's why it's getting the attention that it gets in the media. And the media is permitted and should be there to report to the public. And they're usually present for more of these type of emotional court hearings. But as long as everyone understands and that they're going to have an opportunity to speak when it's appropriate, the victim advocates communicated that to, I'm done. Sorry about that. But yes, being prepared for it, knowing it's going to happen and being prepared for it.
Thank you. Thank you. At this time, we're going to move to our closing statements, and we'll begin with Ms. Hammoud.
Thank you. So I was not born here. I'm an immigrant, and I came from Lebanon, and living in a different type of country where we don't have the legal system that we have here. I understand, and I really appreciate and never take for granted the rights that we are entitled to living in the country. And I think that my experiences as an immigrant are what drove me to want to be a voice for people, to help them. And that's why I became a lawyer. I did not always know I wanted to be a judge, but I knew I always wanted to help people. So I went to law school, I became a lawyer. And as I practiced and saw the impact that judges can have on a larger scale, much larger than attorneys, that's when I decided I wanted to be a judge. And I've always felt that empathy is a lawyer's greatest tool. And I tell new lawyers that all the time. And it's funny because a close friend of mine came up with the same exact quote as she was mentoring my cousin, who's now in law school. But I believe that the same is true for a judge. Empathy is a judge's greatest tool. And you know, wanting to be fair and wanting to apply the law equally, and in the pursuit of justice is exactly what a judge should do. But if you don't have the empathy, if you don't have the life experiences or the professional experience, I just don't see how you can get to be the best you can as a judge. Thank you.
Thank you. Mr. Worrells, your closing statement.
Thank you. As I've stated previously, I've always wanted to be a judge, and I think this is a great opportunity. Having been a litigation attorney experienced for over 12 years, I understand how contested matters work. I understand the nuts and bolts of the rules of evidence and the court rules and how to apply the law. I think I have the experience necessary to make me effective in the application of the law. I also think I have the personality traits necessary to be an effective judge as well. I think judges need to be open-minded and fair. I think they need to be willing to listen. I think they need to be calm and willing to be prepared to understand the issues that are at play. I think all those traits combined with my experience make me an excellent candidate to be the judge for Washtenaw County 22nd Circuit. And I appreciate the opportunity that I've been given in this forum. And any further information about me can be found on my website, jeffforjudge.com. Thank you.
Thank you. Thank you both for participating in tonight's session. And now Carolyn Madden will have the closing comments.
Thank you all. The League, the Dispute Resolution Center, the Restorative Justice and UU Civs of the First Unitarian Universalist Congregation of Ann Arbor, and the Washtenaw County Bar Association thank the candidates and volunteers who participated in this forum, and community members who submitted questions. Please urge others to view our forums. Most importantly, please vote in the November 5th general election, either by absentee ballot or in person.
The League thanks the candidates and volunteers who participated in today's forum and the community members who submitted questions. Please urge others to view our forums. And most importantly, please vote in the November 5th general election, either by absentee ballot or in person.